Good morning, everyone. I hope everyone's been enjoying this spring weather this week. Welcome to session 13 of the Thomson Rogers webinar series. We have a great turnout today. My name is Lucy Jackson and I will be your host. Today's popular topic is best practices for healthcare providers in support of arbitrations and mediations, presented by partners Leonard Kunka and Matthew Sutton. Before we start today, we'd like to remind everybody that we are continuing our prize draw and will offer one $50 everything card to a lucky winner at each session. The everything card is a gift card that you can redeem at essentially any place you can think of. We'll pick a random number at the end of today's session, and so be sure to stay around so you can find out who the lucky winner is. Regarding questions and answers, if you have any questions, we ask that you please submit them using the Q&A button at the bottom of your screen. We'll hopefully be able to get to everybody's question either throughout the presentation or we'll save them for the end. All right, let's begin. Turn it over to Matt.
Morning, everyone. Hope everyone's enjoying their morning. I have to thank Lucy first and foremost because she just unilaterally made me partner of the firm, and now I'm just going to ask all of you to send an email confirming that you witnessed that so that I can send it to my managing partner. Nonetheless, with respect to our discussion today, the good news is that most of it will probably be a refresher for you. You've been doing this for a long time, and hopefully not much of it is going to be new. I also hope that it's an informal discussion for us, and that perhaps there will be one or two things that we can remind you of, or that will be new to you that you can take with you. The primary purpose being that you'll be able to understand where we're coming from later on down the line after you've been treating or assessing clients for some time. And then, unfortunately, a dispute arises and we need to get ready for an arbitration or a hearing. And the types of things that we, Len and I and Lucy, would like to see in reports or in the control of the file moving up to the hearing that allows us to be, most adequately prepared and some of the shortfalls that we see sometimes. So I'm just going to take control of the screen here. Okay, so I think the first thing that comes up is just important initial and ongoing discussions with the counsel who's on the file. We try to keep discussions ongoing with the adjusters as well. The idea is that we can brainstorm together, come up with ideas, understand the file, the initial concerns, and then move together organically so that there's a good understanding, and it helps build the relationship too, so that if issues come along down the line, we're able to discuss them comfortably. The initial assessments are important. In this day and age with the coronavirus pandemic, it needs to be included in almost all files. You'll know with all your clients, the marked deterioration we see when there are times without treatment, and the different types of treatment we have to provide now, especially with physical issues where perhaps you're not able to see the person or that there's a variability to being able to see the person. The initial assessments that we see that are helpful, think of the worst case scenario, basically. We don't know when the rainy day is going to happen. We'll all hope that it doesn't happen. But if there is some understanding or idea as to what could happen in the future for clients and an anticipation of their future needs, it doesn't become a surprise to the adjuster later on, 6 months later or so. So I'm just having a bit of an issue moving to the next slide. There we go. Progress reports are extremely helpful throughout the balance of the file as you're helping clients move on. Something that we've noticed with adjusters is that, and cut and paste is just a general need in a lot of reports. You have a 30-page report, you don't have to write the background information in a bunch of different ways, but We do find that in certain types of reporting like that, it becomes unpersuasive to the adjusters if they see what almost seems like the same report again, with the same recommendations. And some suggestions for that are just to maybe have a summary at the beginning, or highlight the new and different issues right off the bat, or even have more clear and concise progress reports documenting those issues. This is also a great time right off the bat to get into a scenario where you can start telling the client's story. As a healthcare professional, you're meeting them, you're seeing them in pain, you're seeing them struggle emotionally or otherwise. And they'll be talking to you, they'll be telling you about that, or hopefully enlightening you about how that's affecting their lives. And these progress reports are great times to kind of humanize the client for the adjuster. So they read, an information piece about what's going on and be able to look at it and say, okay, I can understand what that person's going through. Collateral information is a very persuasive tool for lawyers when we get to a hearing. If we have reports and we know that our healthcare providers have spoken to family members or people living in the home, and they can corroborate or at least lend some understanding to what the client is going through, it's very helpful for us to know, what witnesses we can rely on at the hearing and otherwise. Sometimes the clients don't know how bad they have it too, especially with brain injured clients and otherwise. And so when you have that collateral information to rely on with memory issues and otherwise, you can have a third party kind of explain the real difficulties and then use that in your report to show the documented needs. Review and cohesion with other reports. This is something you might not think about at all, but is very helpful for us, is that towards the times when things are being disputed, having the ability to review medical documentations for your assessments and look at what other people have suggested and chime in and give your opinion, that's helpful, creates a cohesion to the entirety of the plan moving the file. And so there's some consistency there that can speak through the evidence that shows like, hey, okay, everyone seems to feel that this individual needs emotional counseling. That's important for them, as an example. Don't be afraid to be creative. I remember back in the days, and Len, you'll remember this, when iPads came out, everyone got an iPad on their treatment plan and the insurance companies got mad. Hot tubs had a few years where they were a big hot ticket item and the insurers got upset because it seemed to be consistent. But there are really clients that benefit from those types of devices. In COVID, we're seeing Invisicare as being a very instrumental treatment tool to be able to help people who need reminders and otherwise check-ins, daily check-ins when the, treating PSW or other people aren't necessarily being able to see them in person or otherwise. So feel free to be creative, but just remember that you have to prove that it's reasonable and necessary. And I'll move to the next slide. Function is key. Function changes everything because that's how the client's lives change. They have their life before the accident or injury, they have their life after the accident or injury. And that's how we prove to the adjusters that life has changed and they need treatment and services. Physical and psychological impacts can be different but provide similar functional issues. If we have a catastrophic client, they're looking at a significant impediment on this function. And the way that we highlight that, especially in the initial basis, is set the groundwork through your reports and otherwise. And taking a look and seeing exactly specifically how their function is changing can provide a real, important persuasive tool for us. And you're in the best position to do that because you're on the ground working with them. Some things we found helpful is when healthcare providers remind the clients to, keep their invoices and journals, document their struggles. You may ask them in an assessment and they won't remember to tell you, or it just won't be a problem for them that week. But if they have a journal or something that they keep going, then they can write down, certain issues that they're having that can be quite helpful later on.
Matt, I would just jump in here and
Yeah.
add one thing. I think that the focus on function ties into one of your earlier comments where you were saying that the healthcare provider should help tell the story. This is a perfect opportunity to give sort of real life examples of impairment of function, because people tend to understand that stuff better than 50% or 60% of normal. That's hard to understand if you don't know what normal is for that person. So it's a good place to give real life examples of impairment of function.
Absolutely, that's a great point, Len. It's a litmus test, really. It's pre and post in the changes, and that is great, and maybe leads into my next point about your recommendations as a healthcare provider. As the accident happens, the afterward effect, maybe a few years go by while they're being treated. Those recommendations may change as required, and you need to keep that in mind, since there is a real reality to the fact that certain treatment may be necessary right at the beginning, and it changes over time. You may find that certain recommendations you made anticipating a rainy day don't necessarily come to fruition, but that other things that you weren't necessarily thinking about have now come into mind, and that's important. Next slide, please. Cueing and prompting. This is much related to function. It can be pain related and cognitively related. Sometimes people are in so much pain, they're not paying attention to the traffic signal or something of that nature. And as a healthcare provider, it's really important to document these needs for someone to be around the person to make sure they're safe. Cognitively related issues of alternative thinking, executive functioning decisions, memory issues, those things are really much more obvious. And I would suggest to the healthcare providers, especially the OT assessors, to think about, okay, how would my client handle an emergency? You could imagine with a leg issue and being at the top of a house with lots of stairs, that may be an issue for a certain time period. I had a client where there was a carbon monoxide detector that he would just take out, unplug if it started making noise. That he needs someone in that house to make sure that if there's a fire or something, that he'll be ready to get out of that house properly.
Matt,
Yeah.
I saw there was a question from one of the viewers about do we prefer will-say statements or notarized statements of clients if there's information that a healthcare provider is providing in the report. What would you say about that?
So it's just in terms of, I guess, for just providing an assessment. Will says are a great starting point, I find. Notarized kind of cements the information a little bit more in collateral interview and otherwise. I know certainly what we do is get an idea as to what that witness is going to say, and by just giving a heads up, like, hey, I spoke to this individual, they've indicated this. It allows room to maneuver should things change as time moves forward. It also allows the lawyers to kind of assess it in a way prior to there being a signature or something that kind of cements that evidence as a reality. So I would suggest the will say is a better way to go initially. How do you feel, Len?
Yeah, initially I would say so. If the matter is proceeding to an arbitration or to a mediation or to trial, then obviously getting a signed statement is something that we would need, because we often have to exchange information with the other side. It's nice to show that you have a signed document from somebody that's been notarized or witnessed, so that they know that you're not just blowing smoke, that this is actually the evidence that's going to come from a person live.
Excellent. Yeah. Okay, good. Yeah. And the lawyers can usually do that too in terms of stat declarations or affidavits. We often can prepare it and kind of work with you in terms of getting the right evidence out there as the file requires. Next, I came up with this thought about, if this in any way functional issue or need for treatment is stemming from the accident, don't worry about causation so much if this person has a pre-existing history or otherwise. Really focus on their functional needs and what they need at that moment. And one of the examples I thought of in terms of how that can differ among clients was stairs. there are people, amputees, that may not have a problem going upstairs or downstairs, but some will require maybe a handle or a rail. Some will require a chairlift, and some may be in a wheelchair. They can never, ever successfully deal with stairs in a way, with help or without help, and they'll need a new home that's a bungalow. You don't shy away from what you need for that specific person, considering what type of assistance they're going to be required moving forward.
And I would just add to that, Matt, that if the person does have a pre-existing condition that you're concerned about, that the insurer is going to try to argue that, this is not something new, then it's critical to set out the difference between the way the patient was before, even though they may have had a disability or had some problems, and how things have changed as a result of the accident. And that usually helps us in terms of establishing that they need either a new piece of equipment or some type of rehabilitation, which they were not receiving before.
Certainly, yeah, and you're right. Sometimes it's going to be nice and clear, and that's great. And I was probably being a little unclear because I was thinking of those muddled times where you're not necessarily sure of what's happening, especially with psychological issues or otherwise that are causing a problem. And that's why we hire you, though. That's the good news, is that as the healthcare providers, you guys do understand that and can provide and help us in that way, as opposed to us trying to dictate. But Len, that's a great point. I mean, if you have issues with an arm, but pre-accident they had issues with the leg, there's a great way to be able to look at function with upper extremities versus lower extremities that will be really clear to an adjuster, and they'll be able to approve the reasonableness and necessity of that.
And the other thing that just kind of came to mind is often with people who have some sort of pre-accident condition, the accident injures a part of their body, which was the only good part of their body that was left. And it makes their condition even worse than if they had that injury alone. So it's important to set that out, where an accident-related injury has actually put the person into a worse condition because of their pre-accident situation.
Absolutely. The straw that broke the camel's back, so to speak. Yeah, certainly. And at the end of all this, as healthcare providers, the test for treatment and otherwise is reasonableness and necessity. And so you want to think about what they really need and why, and be able to back that up. And ultimately also remember your importance. One of the things I see sometimes is too many assistive devices where the PSW or OT treatment will be better, and you don't want to say that a long handle or something is going to take place for someone who needs to be in the home to help. So keep that in mind, and make sure that when you're putting in your recommendations, you remember your value and what you're providing, and that you request the ongoing treatment there. Next screen, please. This is kind of a catch-all slide. I was thinking about team meetings and case management. Usually that comes at a catastrophic level, but I've had files where team meetings have worked with and without the adjuster at the non-CAT level, and they've been very, very helpful because it creates a cohesion in terms of plan moving forward. And just generally speaking, as a healthcare professional, you want to consider some of these comments. When we're going to arbitration, we need to qualify you as an expert, and so keeping an up-to-date CV is really important. You want to document all those people that you've assisted moving forward, so that there's a real understanding of where you come from experience-wise that can help you out. With clinical notes or just general notes and records, this is a question, and Len, please chime in on this. I still don't know the answer to this, but sometimes less is more, because you can have a scenario where you're focusing on the right issues and just documenting consistent complaints or consistent issues. Sometimes more is better because you can get those stories in. What do you think, Len?
Yeah, I mean, I think that you can deal with that if a person is continuing to have the same sort of problems they were having in the last time you did a report. You can cover that quickly by saying, these things are unchanged. And then, as Matt said earlier on, focus on things that have changed or improvements or deterioration. That's what adjusters are looking for in reports. They want to know what the progress is like. So, reading 2 and 3 pages of, everything is the same as it was in the last report really doesn't help the adjuster much. They're trying to see, is the person improving? Are they deteriorating? Are things staying the same? I mean, if things are just staying the same, then that's the answer. But they're always looking for areas where there's improvement or deterioration.
Excellent. Yeah. Okay. That makes sense. Communication, make sure that if something's bothering you and there's a lawyer on file, speak to them about it. You might see a denial coming, or you might see that the adjuster's focusing on something that you might find relevant or irrelevant, and sometimes we can help out in terms of directing the approach. With consistency of AB forms, that speaks back to one of my first points, is kind of being top heavy in the initial assessments and then being able to work through so that they're not seeing something new as we go along. Another thing that I know with treatment plans is there's that additional comments on the form, and a lot of you will utilize that and put in some great information, but I find that stuff gets ignored sometimes. It just seems like standard type, and for whatever reason, the adjusters, there's so many times where I said, hey, did you read the additional comments here? And they'll be like, oh, I missed it or whatever. So I find that having the progress report or updated report that's attached to the assessment plan, sending it separately, it seems to be a little bit more persuasive than that. Next slide, please. And just finally, as we go along, we'll see the disputes, we'll know what the issues are that will help our focus. And so we may say to you, hey, attendant care is really the issue here, and focus on that, or maybe it's physio, and speak with those healthcare professionals and document and look at what do we need from you to convince us that this is something the client still needs. And usually there's a lot of answers, and then we can go through that through the reporting. But sometimes when we're getting ready for an arbitration or hearing, the healthcare providers will focus on issues that aren't in dispute. And so hopefully we'll be able to provide you through preparation, the guidance or other things. But as you move along with the file, it's good to highlight really what's the problem from the adjuster standpoint and how we can fix that, as opposed to other issues that aren't playing along. If as a treating OT or other type of provider, you're asked to participate in a go-see assessment for a brain injured client, or situational assessment perhaps for marked impairment issues or otherwise, there's no harm in calling the lawyer to make sure that you understand the legal tests required with the assessment and how the interplay is with that. Hopefully we'll have other webinars on that. I know we've done them before, but it's important to know exactly what to look for in those issues, because they get quite complicated. And for a situational assessment, for example, it's being provided for the benefit of the neuropsychologist or other type of psychiatrist that's going to be writing an OCF 19 for the application, and they need to see the functional changes because they can't get that information through an initial assessment. And then just finally, and I said this earlier, if you see a denial come in, just call the lawyer and let them know, and then they can help maybe nick it in the bud right at the beginning. I think that's it for me. Elisa, you can let me know if yep, that's it. I hope that was helpful, and I'll turn it over to Len for the tort side of things and mediations.
Thanks, Matt. Lisa, if we can get the first slide. Just because of time, I'm going to try to move through the tort section fairly quickly. Lisa, if we can have the next slide. Much of what Matt said regarding acts and benefits applies to tort, mediations, and pretrials. I always look at pretrials and mediations as a dress rehearsal for the trial. You're getting an opportunity to see how one other person at least reacting to the way you're going to present your case, whether that's a judge or a mediator or an adjuster that comes to a mediation. So you get to find out what issues seem to be resonating with the insurer and what issues they're having trouble with. So that's always a good way to think about what's happening from the legal perspective when we're going to a mediation or an arbitration. As Matt said in his presentation, the most important thing I find in going to a mediation or a pretrial is changing the way the reports focus on sort of medical issues. When reports are being given, they tend to be very medical. But when we're going to a mediation or to a pretrial, we want to humanize the case. We want to humanize our client. And it's more important for those type of procedures to have reports that focus on real life things that people can understand. So this is where we talk about, giving real life examples of how, function is affected by reason of the accident. Often, and this is something you should speak to the lawyer on the file about. It's not unusual for us to, bring an OT or case manager or someone along occasionally to a mediation or to a pretrial. I think of a case recently I had with one of my partners in a medical negligence case where future care was a huge issue. We had a large future care report. The defendants had hired a fairly well-known OT who suggests that even quadriplegics don't need any care. And so future care was a huge issue. And we brought the future care assessor to the pretrial, and having the person who writes the report and knows the client or has been working with the client, sometimes you're going to bring an OT or the treating OT with you. It's so valuable because it allows the judge or the mediator, to speak to the person who actually wrote the report. And you can be so much more convincing than us just repeating what you've said in your report. And in that example that I was telling you about with the pretrial, it was the difference between the judge basically being on the plaintiff's side in terms of future care versus being on the defense side, just because we had the future care assessor there at the pretrial to explain why not only her report was reasonable, but why the defense report really made no sense and just, didn't, it really didn't stand up to the test of what was happening with the client and what kind of problems they were having. So when we talk here about observations that the client looks sad, it sort of ties in with one of the comments below about making the person human and humanizing the story. That's what we have to do at a mediation, and that's what we have to do at a pretrial as well, is try to get a judge or how the person is affected on a day-to-day basis. And sometimes that's different than the way that you're going to be doing your reports as you're reporting regularly to the insurer. So it's not unusual for us to ask for a report prior to a mediation or a pretrial that changes that focus and asks you to give more concrete examples of how a person is affected on a day-to-day basis. One thing that is missed, I think, a lot of the times is how is this going to play out in the future? How are this person's injuries going to affect them on a long-term basis? And is there going to be deterioration in their condition? It's probably what I would say from what I've seen, it's one of the areas that is most frequently missed, not necessarily by the healthcare providers, but even by lawyers. They don't spend enough time talking about the future and talking about deterioration in condition and how that's going to affect things like attendant care, how it's going to affect future medical treatment. And that's particularly so where a person may be getting by right now with less treatment than they're going to need as they age. So it's always important that the reports touch on that issue of future deterioration and how that's going to affect things like attendant care and future medical needs. The other big issue, obviously, when we're going to a tort mediation or to a pretrial is the issue of whether the accident benefits case is settled already prior to the tort case proceeding. And if that happens, it's important that you speak with the lawyer and ensure that there is a plan in place for treatment to continue. Nothing undermines future care report more than going to a mediation or to a pretrial where the accident benefits case is settled and the client has just stopped taking treatment. they've taken the money and they've stopped treating, they've stopped, they don't have a case manager anymore. That just kills our future care claim, and it kills the client's future care claim. So it's very important that if the lawyer that you're working with is in the process of resolving the accident benefits claim and the tort claim is continuing, that treatment continue, and that you're involved in that process and you help ensure that the client is continuing to treat so as to not undermine the future care report. Next slide, please, Lisa. So obviously, as we move toward either an arbitration on the accident benefit side or toward a pretrial or a trial on the tort side, your role as a healthcare provider changes from someone who's providing reports and providing details to us about a person's ongoing treatment and their progress to becoming an expert and being called as a witness at the trial. So it's important that as Matt mentioned in his slides, that there's consistency in your reports, that you're going to be able to stand behind the opinions in your report. Because once you come to trial, and also if you attend with the lawyer either at a mediation or at a pretrial, the court is going to be looking at you as an expert, and they're going to challenge or question you relating to your opinions and how you've come to those opinions and why you say certain things are necessary, why you say certain treatment or care is necessary. So you have to be prepared to deal with those. It's important, the dialogue between yourself and the lawyer as you approach mediations, arbitrations, or pretrials and then trial, the dialogue has to continue with the lawyer handling the file so that you know exactly what issue you're going to be giving evidence about, and you have to focus on that particular issue. A lot of healthcare providers get into trouble at trial or at an arbitration because their report talks about a lot of things that are not really in their area of expertise. And that's how defense counsel attacks healthcare people when they're giving evidence. They pick and choose from your report, and they try to pick apart things that you don't really have the expertise to be giving an opinion upon. So you have to be careful when you're going to an arbitration or a hearing. And when I speak of arbitration or a hearing, I'm talking about going to the LAT. I mean, previously they were called arbitrations. Now I guess they're called LAT hearings. But when I say arbitration, I mean going to the LAT for a hearing at the LAT. And when I talk about mediations, I'm talking about tort mediations, private mediations that are organized between defense counsel and plaintiff counsel and a private mediator. So in this slide here, we talked about focusing on your area of expertise, answering specific questions that the lawyer asks you to deal with, and the lawyer should ask you to deal with things that are only within your area of expertise so that you don't run into this problem of getting outside of your area of expertise. If something crosses into some other field that is really not your area, defer to the other experts in that area and let them speak about, if you're not a psychologist, let them speak about psychological issues. You can certainly comment on symptoms or things that you see that are affecting the ability to treat the client that may be outside of your area of expertise. But in terms of giving opinions, you want to be careful to stay within your own area of expertise. The other area that sometimes I think that treatment providers get into trouble with is on the area of loss of income. And how does a person's injuries affect their ability to work? And it's a touchy subject because as a treatment provider, you're providing evidence about function, which obviously is going to go to the issue of can a person work or not. But I think you've got to focus on in your reports on the functional aspects that would support our argument or an expert's opinion that we will get on the issue of whether a person can return to work or not. That's not necessarily, if you're an OT or if you're a physiotherapist, it's not necessarily your expertise to comment on, do the things that you're seeing from a disability side impact on the person's ability to work. You can certainly talk about, a person can't stand for a long time, they can't walk for a long time, they can't sit for a long time, but we have to actually get an expert with respect to employment and function to correlate those symptoms with the person's job and whether that person can return to work or not. So that's another area where I think that healthcare providers have to be careful about the comments that they make in their reports. Matt said this in his section of this discussion, that where you agree with certain recommendations of other experts, you can certainly include those in your report. You can say that you've read, the other recommendations from other experts and that you agree with the things that they say. If you can support some of those opinions or support some of the things that are being said by other experts from your own observations of problems that a person is having, then by all means, that's good. You're just providing additional information that we can use to help support the various opinions that we have in the case. Next slide, Lisa. So really, from a tort perspective, that's about all that I can say in terms of helping people prepare. I think it's important for you to have a discussion with the lawyer handling the file about whether they would like you to come to a mediation or to a pretrial to assist, because personally, I find that very effective. As a lawyer, you're always subject to the argument that you're just, you're putting a spin what might be in someone's report, in either an OT's report or the future care assessor's report. That argument goes away when we bring the health professional to the mediation or to the pretrial. The judge or the mediator is going to hear from you live, and you're going to defend your position just like you would defend it in court. And that, to me, is far more persuasive than me saying, oh, this future care provider says that this particular client needs X, Y, and Z. So it's a discussion that I think is useful to have with the lawyer to see if you can assist by coming to a mediation or a pretrial.
Great. Thank you, Len, and thank you, Matt. I see we're a bit over time here, but I don't see any questions in the Q&A box here. So maybe we'll just draw our lucky winner at this point, unless anybody has any questions. I'll monitor the box. But Matt, can you pick our number here?
I think they deserve it, having to listen to us drone on for extra time. But here's the magic bag of numbers. And the winner is number 55.
Okay, 55. Carolyn Notarandrea. Apologies if I mispronounce your name, but Carolyn is the lucky winner for today. So one of the members of our team will email you, Carolyn. So keep an eye out for an email from the Everything card. So with that, thank you everyone for joining us today. And be sure to look out for the next Thomson Rogers webinar session, which will occur in April. Thank you, everyone.
Take care.
Thank you, everyone. Take care.